Good morning. This is Ron Mickens. Fraud upon the court. You know the topic. Fraud upon the court by our judges and our attorneys, the officers of the court. Fraud upon the court makes void the orders and judgments of that court. Repeat that again. Fraud upon the court makes void the orders and judgments of that court. Now, Sheriff Grady Judd and Sheriff Crow, Lawrence Crow, previous sheriff, they conspired and agreed to conduct this conspiracy with Jerry Hill and based on Jerry Hill's fraud. Okay? Sheriff Judd and Sheriff Crow, number one, participation in this conspiracy was to enforce fraudulent, void orders and judgment under false pretenses. In other words, you don't have to follow or enforce unlawful orders when you are in full knowledge that they are fraudulent. If you're not, then you certainly should be. Okay? But ain't no doubt about it. Ain't nobody's this incompetent. No sheriff is that, incompetent. Okay. So, Sheriff Crow and Sheriff Judd, they both participate in this conspiracy and this cover. It constitute them violating my constitutional and civil rights. Okay, they depriving me due process and equal protection. They trespassing on my property. They interfering with my possession of my property. It's theft, illegal seizure. Okay, these are criminal acts acting under false pretenses by our share, and more important than anything else, enforcing void, fraudulent orders to justify locking us up or killing us. So, let me get into these. This is just these fraudulent orders, void orders. We have to start with Judge Moore. Fraudulent misrepresentation, material misrepresentation. The only thing that you can get from one lie is another lie. So, stay with me. Okay, Judge Moore fraudulently misrepresented that Ron and Gloria Mickens essentially desired and sought rescission. That is a fraudulent misrepresentation. Okay. On appeal, we certainly objected. On cross appeal, our opponents, they objected. They had corroborated and agreed with us that this representation, material representation, was factually and legally incorrect. That's fraud. And they say for a number of reasons. One reason was that Ron and Gloria Mickens had an adequate remedy at law in our breach of construction contract act. When breach of contract has been is available, then rescission is unavailable. It don't even exist. So this shows where Judge Moore is lying. They stated that Ron and Mickens had a cause of action, a claim and a cause of action for cancellation of deed, a rescission of the deed, but not the construction contract. Okay? They said that both parties, we both, had been denied due process and equal protection. They said also that Judge Moore had found the Damron guilty of fraud. Okay? Fraud what? Vitiates everything. It corrupts everything. When you commit fraud, you're not entitled to any relief in equity or law. Judge Moore clearly in the judgment against their complaint. Their complaint was frivolous. I told you about that preemptive strike. They were never plaintiff. They just obstructed the real plaintiff from filing as the plaintiff. Damron, not Stewart Title, had a cause of action, had a right to sue us. Okay, so you see this fraudulent misrepresentation supported too by both parties. But let's go on with this fraud on the court. Judge Moore orders us to pay Damron for the cost of materials and labor when he's entitled to nothing. He's a nominal party. Okay? He's not a real party in interest. She don't have the authority. She entered judgment against his complaint. He committed fraud. When you commit fraud, you're not entitled to any relief in equity or law. I don't want to sound too repetitive, but he's not even a nominal. He's a nominal party. He's not entitled to anything. Okay? Now, here Judge Moore, too. Give an order to so-called inspect property. Want this contractor, want us to have two contractors come out to the place, assess the cost of malaria, the cost of materials and labor. And she orders Ron and Gloria Mickens to permit inspection of property or to permit discovery. Okay, this is fraud. This is a trick. She's trying to trick us into giving our consent to participate in a process to deprive us of all of our claims, to deprive us of all of our constitutional and civil rights. Talking about ordering us to consent. That's not consent. How you gonna order somebody to consent? If you got the ability or the right to give your consent, you have to have the option to volunteer or not involunteer or not volunteer. If you're going to order somebody to permit or give permission, you got to have the right to say yes or no. Order somebody to permit, that's fraud, ladies and gentlemen. Okay, you got to see through. You got to see through the illusions. Okay, now on appeal and cross appeal, the opposing party too corroborated and agreed with us. And I'm going to read to you verbatim, this abstract from their cross appeal. They said the court erred when it failed to award damages supported by the record and directed the parties to submit additional evidence. The prior appeal of this cause resulted in the reversal of the prior final judgment and remand to the trial court for entry of a new judgment which is supported by the record. Okay, they reversed Judge Strickland's own personal, unique remedy on the first appeal. Okay, because it was unsupported by the pleading, unsupported by the evidence, unsupported by the record, and objected to by both parties. The same as this order. Okay, they go on. They said the cause was not remanded for a new trial, nor was it remanded with instructions to take additional evidence. The remand was simply limited to entry of a judgment supported by the record. Neither Damron nor the Mickens asked for an opportunity to submit additional evidence on damages. By directing the submission of such evidence, the lower court erred by exceeding the scope of the remand. This court has clearly recognized that no principle of appellate jurisdiction is more firmly established than the one which provides that a trial court ultimately lacks the power to deviate from the terms of an appellate mandate. In addition to being beyond the scope of this court's mandate, the evidentiary hearing ordered by the lower court was and is unnecessary with regard to the existing record. This is a fraudulent order, trying to get us to participate in a process that's detrimental to us, the prevailing party, and beneficial to the losing party. Now here we go too now, because when the case get to Judge Constein, the first thing that he has to do is commit this fraudulent act. Judge Durrance and Judge Prince have consolidated the three lawsuits into one case because they're what? They're inextricably tied together. They're interconnected. They're interrelated. They're integrated. They're intertwined. They're all necessary and indispensable parties in one case. In one case. I think we've already made that clear. Damron had been named in all three lawsuits. Fraud had been alleged in all three lawsuits. I think we can see how the Damron, Stewart Title, Polk, Stewart Title Guaranty Company, Canady, Rewis was all what? Interrelated. They were intertwined. Damron couldn't commit any of his fraudulent acts without Stewart Title's fraudulent acts. But Judge Constein got the line. He's going to unconsolidate an unseparable case. Okay, separate means to separate, like they're independent. Three independent lawsuits. Now he's lying because now he's saying that they're not interrelated. He's saying that they're not interconnected, that they're not integrated, they're not intertwined, they're not inextricably tied together. And I just proved to you that they were in direct contradiction to Judge Durrance and Judge Prince. Okay, stay with me. Now, let's get back to this so-called order to inspect property. Make sure you understand that this is depriving us of all of our constitutional rights, forcing us to give our consent or give permission. That telling you that you don't even have any rights. Now, they did not give Damron a judgment based on we not participating in this so-called inspection of property. They gave Damron this judgment based on an accusation made by somebody we never heard of, never saw before, based on an accusation as showing where we're being deprived of due process. You investigated an accusation. It ain't even an allegation. You establish probable cause. You prosecute and you develop, or you establish cause, a just cause. But they gave him this judgment for over $200,000, without providing us with any due process whatsoever. Okay? This is fraud on the court. Now, after they give Damron this frivolous judgment, purporting that he's in a real party in interest, they dropped him from the lawsuit. They can't let Damron be in the same lawsuit with us because of his fraud. So they faked this first judgment. Now they're going to let Stewart Title so-called drop him from the lawsuit in exchange for Stewart Title dropping the foreclosure action against the Damron. Now Damron going to this warranty deed here. He's going to transfer the property to Stewart Title Guaranty Company outside the lawsuit. He already got a frivolous judgment. Now he's got the ability. He's got the fraudulent ability. And this is what, like Sheriff Grady Judge Strickland, the trial judge, and Judge Moore done found this man guilty of fraud, done voided his fraudulent quitclaim deed. But they protected him fraudulently transferring our properties to a title guarantee company. And then they give Stewart Title Guaranty Company 2 fraudulent foreclosure judgments against Ron and Gloria Mickens. No cause of action. We never heard of these people. They can't foreclose on anybody. They accepted a quitclaim deed. They don't have a cause of action against Damron, us, or anybody. Okay? They got the whole clerk of court office faking foreclosures. These are criminal acts. Okay? But they're using these fraudulent orders and judgment under false pretenses. It's a setup to have first responders to lock us up or to kill us. Now, first responders, when they get orders from judges, the sheriff, or they don't ask questions. They should, because I certainly had explained to them all that these orders were fraudulent. But the fraudulent orders just keep piling up, because now here you got the federal district court adopts Jerry Hill fraudulent misrepresentation, Judge Moore's fraudulent misrepresentation, and fraudulent orders and judgment. Call us state court losers. They adopt these fraudulent misrepresentation in direct contradiction to the trial judge. The trial judge findings of facts on the merits of our claim is binding. They cannot be overturned. That's why the Second District Court of Appeal didn't overturn them. They didn't have the authority to. So Judge Moore using this trick to replace, to ignore, to abort, to abandon. These are criminal acts. These are serious criminal acts. This is warring against the Constitution. Okay? This is violation of her oath of office. This is interference with interstate commerce. Ladies and gentlemen, these are serious crimes done maliciously, intentionally. Lord knows it's intentionally. So what? Stay with me. I'm going to get into Rooker-Feldman a little bit deeper in video down the road. But this was the playbook for state court losers. So that's what the Federal District Court of Appeal labeled us and branded us as state court losers, claiming that the property had been foreclosed. That's a lie. It was fraud. Those foreclosures are fraudulent. This too is in direct contradiction. They saying that our property was temporarily transferred. That's a lie. There ain't no such thing as a temporarily transferred. They said that Stewart Title Guaranty Company, Stewart Title Guaranty Company, Stewart Title of Polk, Canady, Harman-Highsmith, was responsible for the deed. You can't be responsible for a deed to our property that we don't know anything about. We don't know you all. We never seen you before. We never heard of you before. Okay? Damron was a con artist. They knew this. They were building houses under false pretenses. I'm a veteran. Okay? Supposed to be being protected by the D-Day. Okay. So you got to hang in there with me. Rooker-Feldman, I may have to use a few legal terminology, but I'm going to break it down to where it makes sense. There should be no doubt in your mind that these orders are fraudulent. If you got any questions, call me. I'll clarify. My number is 863-646-8255. 603-3073. Now that's all I'm going to give you today. But I'm coming back. These stories and these lies never end until they correct them. One lie leads to another lie. All you have to do is just shine the light of truth upon them. Just like out of